Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, the most fact-driven, unbiased, true crime channel here on the internet. Now, please take a look at the top stories throughout the week. And if you want to catch all the stories, go back and watch all the videos. Have a great day. Good day, Crime Talk aficionados. This is Crime Talk, and my name is Scott Reisch. First, if you haven't done so already, we'd ask that you hit that subscribe button, hit that little bell so that you receive notifications, and as always, leave us a comment below. Now, first on the docket, there's this new secret audio that's floating around out there regarding Laurievalo, and it sounds like to me she's having a conversation for one of these podcasts that she was doing, or sitting around a living room chatting with people. This recording was apparently found by or made by or somehow enhanced by Annie Cushings, who is Tylee's aunt and Joseph Ryan's sister. Now, a lot of people asked, is this an admission? I don't think it admits to anything. And then on top of that, some people ask, is it relevant to the case as it relates to the disappearance of Tylee and JJ? My first response, and I responded to many people and said, well, as of, I think, Saturday, I had not reviewed it. Well, I have reviewed it. I've actually listened to it a couple of times thinking, am I missing something here? And if you listen to that audio, and I think we can put a link to it, we can upload that. But as far as I'm concerned, yes, now there was reference in there by what purports to be Laurievalo stating that she wanted to murder her husband because of the pain and grief, and that somehow she was justified in doing so because she had been wronged at least 3 times, and according to the Bible, that was good enough and it was justifiable. Now, there's some other references about children and kids and evil hearts, but frankly, I don't think that that is going to be relevant or used in any way by the district attorney. There was statements in that audio that simply refer to, I would like to, I wanted to. Well, guess what? That's not an admission. And let's face it, if Laurievalo was going to be charged with the death of anyone, they probably would do it by now. And is that audio the smoking gun? I don't think so. A lot of people may disagree with me. That's okay. That's my opinion based upon what I listened to a couple of times. It's just not there. It really isn't. And if this information was so great, why is Annie Cushings not taking it to the police saying, look, here it is, the smoking gun? It's nothing. People can talk about what they would like to have done to people all day long. And even though this recording was made apparently on October 19th of 2018, where Joseph Ryan had now been deceased by that time by roughly about 6 months, doesn't come across to me as a criminal defense attorney as an admission in any way. And frankly, if it were, she'd be charged by now. She's not going to be, based upon the facts that the police are aware of. Let me tell you, there's nothing more that police would like to do than to charge people with homicides if they believe they have the right person and they can prove it. Remember, when a case is filed, it goes from the police to the district attorney. The district attorney has to review it to see if there's sufficient probable cause to get an arrest warrant. Probable cause is a very low standard compared to proof beyond a reasonable doubt at trial. The district attorney has an ethical obligation only to take that case if they believe at the time of filing of charges they can prove each and every element of the offenses charged beyond a reasonable doubt. If they can't do that, they have an ethical obligation not to charge. So, if this was going to be the smoking gun, they would have been resolved already. It simply is not. I know a lot of people don't like LorivaloChad DeBell. I get it. Understand. But this is why hopefully people come here, which is for straight, honest analysis based upon the law. And I'm telling you, this audio isn't it. Next on the docket, Gillian Maxwell says the U.S. government is slow in turning over her discovery. Well, before we get to that story, let's do the Gillian Maxwell suicided calendar update. Now, I know suicided is not a word, But that was the name that was coined when Maxwell's ex-boyfriend, that guy named Jeff, wound up deceased in his jail cell, and many people thought that it was not suicide, but it was murder. That's right. So suicided became the word of the day. And so we started the Gillian Maxwell Suicided Watch. And today is 124 days that Gillian Maxwell has been able to make it without being suicided. And that 124 days can be converted into 178,560 minutes, 2,976 hours, or 17 weeks and 5 days. Gillian, hang in there. Now, the issue before Gillian's Maxwell case is that the prosecutors have said that they were going to turn over some 1.3 million documents from devices seized related to Miss Maxwell's ex-boyfriend's case, that guy named Jeff. And the defense says, hey, we need this stuff because we have a trial coming up in July, and how are we going to be able to review this, inventory, document, analyze, see if motions need to be drafted if we don't have the evidence? Remember, when the United States government indicts somebody, they should have all of their ducks in a row and say, oh, here you go, defendant. Here's your indictment, and here's all the discovery that's coming along with it. Here's it on disk. Here's a big stack of it like they used to do in the old days where they would drop off literally 20 boxes of documents in your particular case. Now it seems like more and more, particularly in the age of COVID, everything is kind of piecemealed. The United States attorneys, most of them are working from home, not in the office. Their techs aren't working. Things are just slow. But this is a high-profile case. They should have had their ducks in a row. Turn it over. And usually, if the government doesn't want to turn something over, it means they're hiding something. Just my experience. Ladies and gentlemen, in litigation, it's not about what the government gives you, or in civil litigation, it's not about what the other side gives you. You're fighting over what they're withholding. What are they hiding? That's usually what it comes down to. If the government has their bulletproof case, all they need to do is simply give them everything. Give them everything. As my boss used to say, I'll give you whatever you want, and I'm still going to convict the defendant. Bottom line. And of course, the government says, we have turned things over as the case goes on, and that they're working diligently to continue to meet the discovery deadlines in this particular case. Now, the judge can really say, listen, government, here's the rule. If you don't turn the discovery over by this particular date, you won't be able to use it. Judges usually don't do that. The remedy is a continuance if the defense is going to be prejudiced. But at a certain point, the government just can't continue to delay, because they also have that obligation to turn over exculpatory information pursuant to Brady v. Maryland, the United States Supreme Court case that says that everyone is entitled to have all the information that is exculpatory. And I would bet that some of these 1.2 million pages of documents, 1.3 million pages of documents, is exculpatory to Gillian Maxwell. But you don't know until it's turned over. So government, get to it. Now, on another note, guess whose house is getting a makeover? That's right, that guy named Jeff. And remember, we're not saying the last name. Why? Because the YouTube censors don't like that. It flags when we say that last name, and then the videos don't get to be monetized. Well, anyway, a real estate developer by the name of Todd Glazer says that he has inked a contract to buy former residence of that guy named Jeff. And once it closes next month, he's planning to demolish the home and build a new 14,000 square foot mansion. Glazer, the developer, apparently paid $18 million for the property. The original asking price was $21.9. So he got the property to tear it down is basically a scrape property, scrape it and build new for $18 million. What a deal. I'm sure Palm Beach will be happy to see the guy named Jeff's house go away. Next on the docket, more delays in the Leticia Stouk matter. As you may recall, obviously, Leticia Stouk is charged with the death of her stepson, Gannon. Now, Miss Leticia Stouk, through her attorneys, have filed for a competency evaluation. The first evaluation was done, and the defense then filed for a second evaluation to be completed. Now, there's been all kinds of issues regarding this whole competency evaluation. When the first evaluation was done, it was video recorded by the doctor that did the examination. Only problem was, guess what? Under Colorado law, it wasn't to have been video recorded. And so there's been a whole lot of controversy. So since the first evaluation was video recorded, the defense attorneys in the case said, hey, we would like to see that video evaluation, or at least give it to the new doctor doing the evaluation. The court said, whoa, defense, pump your brakes, because there's this issue under the statute. Yes, if there's an insanity defense, those evaluations must be recorded on video. But if it's competency, the Colorado legislature left out specifically competency evaluations to not be recorded. So the judge said, are you sure you really want me to do that, defense? Because if I release it to the evaluator and you, guess what? I have to give a copy to the prosecution who could use that against your client. And since it probably should not have been video recorded, the first incident, are you sure you really want that to be done? The defense then said, hey, judge, thanks, you're right. We agree. We don't want that video to be turned over to our doctor conducting the second evaluation because we agree with you in your analysis that it never should have been recorded in the first place, and we certainly don't want the prosecution to have it and to be able to use that video against our client in the future, particularly if there's a contested hearing regarding competency, not to mention admissions regarding anything that could be used against her at trial. Needless to say, the defense is still agreeing with the court. They filed a motion recently regarding this particular issue, and they do not want the video turned over to the prosecution. The delays are going to come not only from that whole issue about which video, but now the evaluator for the second competency evaluation says that they're going to need more time. So the defense for Ms. Stouk has filed a motion requesting additional time for the completion of a second competency evaluation in her case. And she requests that the hearing scheduled to review competency, set for November 12th, should be continued to accommodate the additional time necessary. The reason for the time that is necessary is that apparently the El Paso County Jail, where Ms. Leticia Stouk is being held, reported that on October 29th of this year that there was a growing outbreak of COVID-19, and it is apparently spreading among the inmates. As of October 29th, when their motion was filed, there were some 72 inmates who had tested positive for COVID-19, and that the jail was basically on lockdown. What does lockdown mean? It means that there are no in-person visits to conduct the competency evaluation. In fact, there are not going to be any in-person visits at the jail until at least November 30th, so the evaluation can't be conducted until sometime after that date, assuming there's not basically a second wave there in the jail. Obviously, the court's going to have to rule on this. They could keep the status date for November 12th, but the evaluation won't be complete and nothing will be able to be conducted on that issue related to competency on that hearing date anyway. No other issues can be resolved as it relates to the Leticia Stouk matter until competency is resolved, right? We can't even move the case forward and do anything of substance unless we know Leticia Stouk is competent to proceed, which means that she understands the proceedings taking place. Yes, ladies and gentlemen, the wheels of justice move slow sometimes. Next on the docket, big news on the case out of Minneapolis, Minnesota, regarding the 4 former police officers charged in the death of George Floyd. And that big ruling is they will all be tried in a single proceeding, which will be televised despite the prosecutors not consenting to any audio or video coverage in the courtroom. The order was released late last night by Judge Peter Cahill, and he also denied requests of the defendants, Derek Chauvin, Tao Tao, J. Alexander Koenig, and Thomas Lane, to have the trial moved out of Minneapolis. All 4 defendants had previously argued that remaining in the city would violate the Sixth Amendment right to a fair proceeding due to the amount of pre-trial exposure. Now, in allowing the proceedings to be televised, Cahill reasoned that the defendant's Sixth Amendment right to a fair trial ran concurrent with the general public's First Amendment right to access to public trials. Interesting analysis, but I think the judge got it correct. I am a big advocate of courts and the proceedings going on in the courts being televised. It's the best way for the truth to come out when people can actually look at it, hear it for their own eyes, and not get some talking heads version which is slanted or skewed for one particular side. The truth is always the best source of information. Under Judge Cahill's order, audio and video recordings, broadcasting, and live streaming will be allowed in the courtroom, with only matters that are on the record being subject to audio coverage. That makes sense. If there's something not on the record, it doesn't need to be televised. The court's going to allow 3 video cameras that may be installed in the trial courtroom, one in the back of the courtroom facing the witness stand, one on the wall behind the jury box, and one on or near the bench facing the lectern where counsel will conduct their witness examination. The cameras cannot be moved from their fixed positions for obvious reasons. We don't want to show the jurors in this particular case. I have said this before. The jurors in this case are going to have a big decision to make. Their identities should remain secret so that they can make a decision based on the evidence or the lack thereof in this particular case. The court's orders today were based upon a hearing that was set last Friday regarding whether there was going to be a joint trial. Now we know there will be. But the defense had all argued that we have inconsistent theories of defenses, which is basically they're all going to be pointing their fingers at each other. Specifically, the attorneys for defendants Lane, Cugin, and Tao are anticipated to argue that Chauvin committed the crime on his own. The prosecutor simply said that they were working in concert together, therefore they should all be held accountable. The biggest argument that the prosecutor had for keeping the trials together was that it was all basically the same evidence coming in against each other. The biggest argument the prosecutors put forth to the court for a single trial was the mere argument of judicial economy. Judge, it'd be really burdensome on the family as well as the court system and the prosecutors not to have to do just one trial, but to do 4. Where have we heard that argument before? That's right, LorivaloChad DeBell matter, right? This doesn't mean that as the evidence gets presented at trial or further offers of proof are made, that the defense will still continue to move for severance. Now, severance is something that you have to move for early and often, and you have to make a record for it. Otherwise, it is waived on appeal. So literally at the start of every trial proceeding, the defendants should each move for severance. Every time there's a bench trial, move for severance. Otherwise, it is deemed waived. I once had a trial with multiple co-defendants. I moved for severance literally every time I went to the bench, every time I got up and spoke, and it resulted in a hung jury twice. And then, right as we're getting ready to start the third trial, suddenly the district attorney thought that there was going to be a good argument for severance. And I said, I object to severance because nothing has changed other than now the district attorney wanted a separate trial. So you got to be consistent, ladies and gentlemen. Prosecutors can get a little sneaky sometimes when they do this type of thing, but the defense is out there holding their feet to the fire for sure. Now, one thing that we have to remember on this George Floyd case is this case will now be prosecuted simply by the Attorney General's office, who is run by Keith Ellison. And that is because early on, the county prosecutors in this particular case held a one-on-one meeting with the coroner in regards to the George Floyd matter. Now, this is a very teachable moment. When I go interview witnesses, I always bring an investigator with me. And the reason for that is if I take all my notes and the witness gets on the stand and says something differently, I cannot effectively impeach that witness by saying, well, isn't it true you told me this when we interviewed you? And they say, no, that's it. So you always bring a third party who can be there to be called as an impeachment witness. In this particular case, and the Judge Cahill, at the time that he disqualified the county attorneys, called it sloppy for him to have held a meeting with the prosecutor one-on-one without a third party there taking notes or something along those lines. Why? Because then the prosecutor was the only witness to that conversation. And guess what? They're now a witness, and you can't be a witness in the case that you are involved with as an attorney. So therefore, you're disqualified. We'll have to see how that case continues to play out. Certainly, that's going to be a trial worth watching for everyone. The primary defense in this particular case is going to be a lot of blaming. You're going to have the defendants blaming Chauvin. You're going to have Chauvin blaming the deceased, Mr. Floyd, by saying that he was a drug addict who was overdosing. And Chauvin's going to blame the other officers who had first contact with Mr. Floyd, basically saying that if you had correctly diagnosed what the circumstances were, then maybe I would have done it differently. But since you failed me, I failed Mr. Floyd, and therefore it's just tragedy, but not criminally responsible. That's what the defense is going to argue. It's going to be interesting to watch. Next on the docket, it's official. Laurievalo and Chad DeBell's cases have been joined. Yes, we had a hearing last week, and the judge in that particular case, Judge Boyce, decided that the cases should in fact be joined. However, the court did state that any motions for severance that are going to come up based upon inconsistent theory of defenses may in fact be made at a future date. We'll have to see how those issues get resolved here shortly when motions hearings actually come around. But for administrative purposes, the court decided that it makes sense to have one judge hear all of the legal issues so that there are consistent rulings. And if it's ultimately determined that there will in fact be a trial, if future motions for severance are not granted, that you have one judge handling all of the cases. As you may recall, Laurievalo had two cases. One regarding the conspiracy regarding the delay and hindrance of the discovery of JJ and Ty Lee. And then she had the previous case, which started out regarding the abandonment case. Those cases have also been joined with no objection by Mark Means. That case that started out regarding the abandonment, which carried up to 14 years per count, those charges were dismissed when the conspiracy charges were added in the new case, and that original case simply has misdemeanor charges that remain. Obviously not a big issue. However, if all these charges are brought and the trials are in fact joined, assuming there's no motions for severance that are granted, there's going to be those additional charges to be heard that only relate to Laurievalo. That's one of the arguments that Mr. Pryor, Chad DeBell's attorney, is going to have to make, that this extra evidence coming in is so prejudicial that it will result in an unfair trial. We'll ultimately have to wait and see. Now, the judges that these cases came down to, Laurievalo's cases were originally assigned to Judge Dane Watkins, and he has been a judge for about 9 years, and prior to that, he was a prosecutor for another 9 years prior to that. Not surprising, that's usually why people go to the prosecutor's office, is that they have some sort of aspirations to be a judge or perhaps a political position in the future. You just never know, and that obviously doesn't hold to all judges. I know many a private counsel that was a defense attorney that has become a judge, and I have found generally that defense attorneys do not make very good judges for defendants, because to make it as simple as possible, defense counsel have heard it all. Usually the defense attorneys are no nonsense and don't like excuses for delaying cases. They want to move it along, and they've heard it all before. Prosecutors, surprisingly, are usually a little more sympathetic, for sure. Now, the judge that will be hearing all of the cases from here on out is Judge Stephen Boyce. He's a district court judge, but he hasn't been a district court judge that long. So Judge Boyce has only been a district court judge since his appointment back in May of 2019. He actually took the place of a judge who was appointed by the governor to be on the Idaho Supreme Court. Now, Judge Boyce was a magistrate prior to becoming a district court judge, and he apparently had been in private practice for a while. Now, what is a magistrate? All right, now in most jurisdictions, at least the ones that I'm familiar with, whether it be federal or the state, magistrates are not appointed by governor. They don't stand for retention. They serve at the pleasure of the chief judge. And what are magistrates there to do? Everything that no one else wants to do. For example, they put the magistrates in the first advisement courtrooms to advise everybody of all their rights, perhaps set bonds. They oftentimes get to go to traffic court, petty infractions, and the worst assignment of all, that's right, they could go to divorce court. That's right. That's where they send the magistrates to do the work that the district court judges simply don't have time to do. In the federal court, the magistrate judges, once again, apply for the position, and the chief judge and the judges on the bench basically hire them, and they handle primarily the civil matters in federal court. They do first advisements as it relates to people being arrested, showing up for court appearances when they've just been arrested, and they hear a lot of preliminary hearings and do a lot of arraignments. And then in the civil matters, the magistrates can hear trials. They handle all the discovery issues. It's all the stuff that's tedious, mind-numbing, that frankly, judges figure, why do I want to have to deal with all that nonsense? Discovery disputes between civil parties. It's the worst. So how does this relate then to Judge Boyce and how he will conduct his court? Based upon what I have seen, he obviously knows what he is doing. And I base that upon the limited hearings that we've had in front of Judge Boyce. He obviously seems to have a good judicial temperament. He seems to be fair, and he's going to be well-reasoned. He gets that this is a high-profile case, and he's going to make sure that his decisions are very deliberate and that they are supported by the law. Nothing more than a judge hates more than getting reversed. So he's going to do everything he can, since he's a relatively new judge, to follow the law. So what does that mean? It means expect the prosecutor to probably get just about everything that they want. Judges like to be on the side of the prosecutor, hoping that they are going to lead them down the correct path, but only when judges get burned a few times by the prosecutors do they start getting into their own. Fortunately, Judge Boyce has some experience as a magistrate, going to know all of the players involved here, and will know when to call BS on either party. So at the end of the day, what does that mean? Hopefully both sides get a fair trial. Justice will be served, whatever that may be, as far as a jury deciding what happened or did not happen. And hopefully no successful appeal. That's always the best thing for both sides. It really is, unless, of course, you're the defendant and you lose. But that's just the way it is. All right. We'll continue to follow that case. We're holding our standards high for Judge Boyce, but I think he's going to do just fine. Have a great weekend. We'll see you next week here on Crime Talk. Be safe.